Yes.
Yeah, 58th.
They're not here.
Yes, Your Honor. Your Honor, we do rely on our petition, which is dated the 18th of October 2024 and amended on the 23rd of October 2024. Our submissions are also dated, our submissions and list of authorities dated the 2nd of January 2026. Your Honor, I'll seek not to traverse grounds that have already been submitted upon by my fellow petitioners. I'll only seek to maybe highlight or underscore cardinal aspects that I think maybe have not been mentioned or have not been given in the flavor that the petitioner herein may have wanted to do. Your Honor, we do submit that, looking even at our submissions, we submit that this impeachment does rest on one singular but profound constitutional question. And simply, this question, which relates to the issues that we've put before this court, is whether the impeachment of the deputy president, the former deputy president, as a fundamental misapplication of constitutional power. In our submissions, we submit that the impeachment process in its entirety is a definite misapplication on constitutional power. And when we speak to constitutional power, we do rest our arguments on Chapter 1 of the Constitution of Kenya. Article 1.1 of the Constitution of Kenya does state that sovereign power belongs to the people of Kenya and shall be exercised only in accordance with that constitution. And when you read that provision, Article 1.1, we are reading it together with Article 1.3, which provides on how this sovereign is to be exercised through delegated power. And this delegated power has been delegated to the three arms of government. And in our submissions is that the parliament violated this power that has been given by the people. And we say that when delegated power, which the parliament wielded so capriciously for political convenience against the very people from whom that power was given, that exercise ceased to be constitutional governance and only descended to be constitutional betrayal. And you see a parliament that indeed betrayed the sovereign power that has been given by the people and conducted an impeachment process that is not only unfair, but also an impeachment process that gravely violates very many provisions of the Constitution. In our petition, we quoted 20 provisions of that Constitution. The petitioners that have come before me have listed a lot of those provisions. I wish not to repeat. But only in summarizing my arguments under Article 1.1, I seek to remind this court of the quote by Justice Emeritus Chief Justice Maraga, when he said that the greatness of any nation lies in its fidelity to the Constitution and adherence to the rule of law, and above all, respect to God. And we also submit that the only way to preserve the rule of law is to apply it equally to everyone. And many petitioners who have come before me, they have said that the impeachment process fell well below the standard of the Constitution. Your Honor, this impeachment process, as it is, opens a constitutional backdoor to power. It provides an alternative way in which the direct vote of the people has an alternative whereby we can easily impeach a leader who has been validly elected by the people through such of a sham of an impeachment process. And we urge this court to shut this door, because this impeachment, the way it was done, it puts the country at a very bad position, and as it has only left a constitutional backdoor to power, which we submit should not be allowed, as it will be an alternative pathway to electoral process, which is the direct power of the people, which is provided under Article 1. On fair hearing, Article 50, I wish not to dwell on this because the petitioners before me have really exhausted this ground. But I wish maybe to remind, I remember when my senior, Mr. Ongoya, was presenting his submissions before you, he listed 3 trials that he termed as predetermined trials with unfair outcome. I do not know the 2, but I know at least the trial of Jesus Christ. And I say in my humble submission that at least with the trial of Jesus Christ, Jesus was given the opportunity to be heard. In this impeachment process, it really, when you look at it, and you look in a constitutional democracy of the 21st century, such as Kenya, with a constitution that is celebrated across the globe, with a constitution that has fidelity to human rights and due process, you can really make a conclusion that this parliament sank very low. Even when you look even at the conduct of the speakers of both parliament, and I also relate it to the trial of Jesus, I say that at least the Pontius Pilate washed his hands when he saw that people could not move. But when you look at the Senate, instead of calling the House to order, they prevailed even to vote. Like the Speaker of the Senate went ahead to put a vote on whether someone's constitutional rights of a fair hearing should be respected. Your Honor, Article 50 contains rights that are not only inalienable, but also non-derogable. And that was a great violation of the Constitution. Your Honor, I seek to move to Article 145 and 150. And the petitioners who have come before me have made arguments both on the threshold and the process. And they have submitted that this process failed in both, not only in process, but also in threshold that is required by the Constitution. 145(3). They made very many distinct legal arguments on whether it is a discretion or the Constitution requires that there must be a special committee. Your Honor, I'll only argue on English, plain English, even literal rule in interpretation of that provision. Your Honor, when you use the word may and you add and, you remove it as an option. When you say, for instance, I want to see, may I see John and James? It is either you see John and James or you don't. And I submit that that may that has been put there is only functions whereby the Senate may not proceed to impeachment. There may even be a preliminary objection, notice of objection on the floor of Parliament, maybe something that has emanated from the National Assembly that prevents even the Senate itself from proceeding to impeachment. But we submit that as per Article 145 and 150, there must be a special committee for investigations. On the aspect of threshold, the Constitution is very clear. It uses the word serious, it uses the word gross. Your Honor, these words are not ornamental. They have a purpose. The framers of the Constitution put them there for a particular purpose. And by use of those terms, it means that there are offenses that are impeachable, and there are also other offenses that are not impeachable. And as such, we submit that none of those charges met the threshold. And I'd like to maybe dwell on the common ground, the issue of shareholder. When you look at the mover of that motion, there's nothing he presented apart from the argument that when the Deputy President was talking about shareholder, those words were divisive, those words were inciting the public. No other evidence was brought in Parliament. Your Honor, what this mover wanted is that he put himself out as an authority tell the parliament, both houses of parliament, that the term shareholder is inciting, the term shareholder is divisive, the term shareholder is against the National Cohesion and Integration Act, without even the institutional backing of that body, which enjoys public money, taxpayers' money, for it to act. Even the Senate did not proceed to conduct investigation so that they can establish these words divisive, as the National Cohesion and Integration Commission deemed it as insightful and divisive. We submit that it lacked authoritative and institutional support. So it was just the words of the mover of impeachment. I believe we dwell on the Latin phrase of ipsit dixit, which simply refers to somebody, a speaker, simply telling people that, believe me, I'm the authority. This is what I mean when I say that these words are divisive and insightful. On Article 152.
Council, you're in your last 2 minutes.
Yes, I'm finalizing. Yes, a minute.
A minute and a half.
Yes, Your Honor. Yes, my lady. Your Honor, as I finish on Article 152, the petitioners who have come before me have made valid arguments on that provision. I seek not to go deep into the legal aspects of it. I only seek to direct this, my lords and my lady, to the Senate Hansard of the 17th of October 2024. I see Mr. Ojenda has been, Professor Ojenda has been attacking petitioners for mentioning Sifuna. Let me make a change and mention Okia Omtata. And Mr. Okia Omtata, these words, even if these words are adequate to prove that this provision was violated. He says that I stand here to look at whether the House has complied with the Constitution, and he mentions Article 152 on removal of the Deputy President from office. And he makes similar submissions to what my senior, Mr. Ndego, has made, that the role of a Deputy President is derivative. So when you move to impeach a Deputy President, you must acknowledge that aspect. And he says that these modifications have been couched as a mandatory. So when you're making impeachment of a Deputy President, you must do the necessary modifications. Your Honor, I will not proceed to, I will rest at this position. My prayers are similar to what other petitioners have prayed for because of time. I'll not proceed to mention and rest my submissions at this position. Thank you very much.
Thank you very much. We have come to... Who are you? Oh? How much time do you want?
But you have given directions, I think.
Okay.
So I will use 5 minutes and allow my colleague to use 5 minutes.
All right.
5 minutes, it's now 2:30 to 2:35.
Just before I start, I just wanted to mention that we have filed our trial bundle dated 15th of April on behalf of Kitusa Sheria, and also our submissions unserved.
Your name again?
My name is Mosongo Maosa. I appear alongside Margaret Awor. May I start? Okay. Your Lordships and your Ladyship, our Constitution contains very many promises. I'll just highlight 5 promises. One of it is the promise of constitutional supremacy, that Kenyans, in exercise of their sovereign power, determined in Article 1 and 2 that sovereign power will only be exercised in accordance with the Constitution. And secondly, that the Constitution will remain supreme and at all times be followed by all organs. They were not fake promises, and Kenyans made these promises because they intended to keep every part of it. What you're arguing is that in this process, the respondents did not honor this promise that the Constitution is supreme and must be followed. Secondly, we want to argue that there was a promise that through all processes of governance, there will be transparency and public involvement. In Article 10 and 118, Kenyans had the good intentions to ensure that the promise that in all processes, the public participation of the people will be inculcated. That promise, they intended to keep it. And we are arguing that the respondents did not safeguard this promise. The third is that there is a promise of fair trial and administrative actions. A promise means everything, and once it is broken, sorry means nothing. The first petitioner had been promised by Kenyans that he will be entitled to a fair trial and a fair administrative action. Your Lordship and your Ladyship, broken promises are the reason why some people are scared to trust again. And that's why if I've asked for 5 minutes and I take more 1 minute, you wouldn't trust me again. So the same way, if Kenyans had indicated that the first petitioner would have the right to ask for an adjournment, to be present and appear, and be able to defend his case, and that right is taken away, it is unfair, and some promises can break your heart too. And in this case, he actually ended up in hospital. That this promise that had been, that he will be entitled to public participation before his removal, was not safeguarded, that the processes relating to his removal would be fair, and it was not fair. He ended up sick. And we are saying that in the same manner, we urge this court to safeguard this promise of a fair trial and administrative action. I still have 1.5 minutes. The fourth promise is that our Constitution, in Article 104, 145, 150, 152, 168, gives the promise of fair removal for state officers. It's not only the Deputy President who is required to be removed in a fair process, but also members of Parliament in Article 104, there's a right to recall our learned senior Professor Tomo Jenda. If the people of Kisumu so wish to recall him, they can recall him, but the Constitution requires that that process must be fair. Even the current president, His Excellency William Ruto, if he has to be removed, the process must be fair. And because we are now setting...
Does this conflict structurally change inflation?
The energy crisis might persist for a lot longer. You know, everything that we import will increase 2x or 2.5x. From a growth perspective, where we thought growth will be in the low 5% prior to the onset of these geopolitical risks, I do think that an entrenched war in the Middle East can shave off at least 0.3 to 0.5 percentage points because of the inflationary impact
One word to describe the next 6 months?
Precarious.
Of this process be safeguarded, that in as much as Parliament did not keep their promise, that this process ultimately, the judicial scrutiny will also be kept. Thank you. I allow Margaret to do the remaining 5 minutes. Thank you, Your Lordships.
Thank you for keeping your promise.
Thank you, my lordships and my lady. Much has been said about public participation, but what I'll hammer home is the public participation that was conducted by the respondents. The National Assembly did not meet the thresholds of Article 10 and Article 118 of the Constitution of Kenya 2010. The Constitution of Kenya, Article 10 and 118 of the Constitution of Kenya provides that the public participation that should be accorded is one that is reasonable and one that is meaningful. The one that was provided by the National Assembly did not meet these thresholds. Why do I say so? If you look at the public participation that was conducted, it was condensed to 47 hubs, which was conducted in a hurry. Let's take Nakuru ASK showground. It encompassed citizens from Molo, Njoro, Naivasha, Gilgil, Kuresoi South, Kuresoi North, Subukia, Rongai, Bahati, Nakuru, Nakuru Town West, and Nakuru Town East. My lords, my lady, this required citizens to travel from far places to one single center, that what they were going to do was to vote, a chat box voting, not an engagement. That did not meet the thresholds of Article 10 and Article 118. Your Honor, sorry, my lords, my lady, you have the mandate or the power to intervene when procedure is not followed, when the procedure that is provided for under the Constitution is not followed. This power is provided for under Article 165(3) of the Constitution, and also as it was hammered in the Wambora case, the Court of Appeal, that you may only come into where necessary to confirm that the process has been properly followed as laid down in the Constitution. We are not inviting this court to intervene or to rewrite politics, but to enforce and preserve the Constitution of Kenya and the rule of law. Our prayers are provided for under paragraph 27 of our replying affidavit. These are our prayers. A declaration that the public participation undertaken by the first and the second respondent in the impeachment process of the first petitioner was neither quantitative nor qualitative as required by the Constitution. A declaration that the notice for public participation issued by the first and the second respondents were inadequate, the time frame provided for was insufficient, and the participatory mechanisms utilized were limited. To declare that the impeachment process failed to meet the constitutional threshold of public participation and is therefore constitutionally defective. Declare that the impeachment proceedings conducted on the 16th day of October 2024 by the third and the fourth respondent were procedurally unfair, unconstitutional, and ultra-vires. Declare that the third and the fourth respondents, acting quasi-judicial, violated Article 47 and 50 of the Constitution of Kenya 2010 by denying cross-examination, re-examination, and a reasonable adjournment. award, of course, to the 7th interested party, who is Kituo cha Sheria. I humbly submit.
What is the date of your affidavit and who has deponed to it?
15th April 2026 by Professor Wambua Kituku.
Professor?
Wambua Kituku.
Thank you very much.
Thank you.
I believe that is the close of the petitioner's submissions. Is there any person representing the petitioner who has not been reached or interested party? We'll break for 40 minutes to come back at 3:20 to commence the respondent's case.